Hi, and good afternoon, and welcome to Venable's webinar, The Present and Future Role of State Attorneys General in Consumer Financial Services Regulation and Enforcement. Today is Friday, December 9th, 2016. And my name is Jonathan Pompan, partner here at Venable and co-chair of our Consumer Financial Services Group and CFPB Task Force, as well as a member of our State Attorneys General Group. And I'm joined by several of my colleagues who will be introducing themselves just briefly in a moment for today's webinar. There's no question that State Attorneys General activity has increased in the last several years and is going to increase consistently in the years to come. They've been involved in consumer financial services investigations and enforcement actions for many, many years, but this trend is going to continue. And whether involving a single State Attorneys General or multiple Attorneys General, investigations and litigation can lead to high costs, administrative burdens, distractions, and reputation damage. Often there may be parallel investigations by federal agencies and risks and exposure from private litigation. And today's session is going to cover all that and more. But first, a couple administrative items. For all of you who are online now, you're going to have the presentation in front of you, but if you'd like it in the future, it's going to be available on our website at venable.com/CFPB/publications, and there's also going to be a YouTube recording available later this week. In addition, for those of you who have any questions during the session, please feel free to use the on-screen prompts and the ReadyTalk access portal. We'll take your questions as they come, as best as we can, and then afterwards, if you have any questions, please feel free to contact any of the presenters today.
Good afternoon. My name is Allison Baker, and I'm a partner here at Venable in the litigation practice and also co-chair of the consumer finance practice and CFPB task force. Thank you very much for joining us this afternoon. I do want to remind everybody on the phone that we have CLE credits that are available. This activity has been approved for minimum continuing legal education credit by the state of California for 1 hour, of which 1 hour applies to the general credit requirement. It's similarly approved by the State Bar of New York in the amount of 1 credit hour, of which 1 credit hour can be applied toward the areas of professional practice requirement. And we will be announcing the code about halfway through, so please stay tuned.
And for anybody who is interested in CLE and going to be using the code, when we do provide it, it'll be available, but the certificate will be emailed after the session as part of our thank you packet, which will also include a link to this presentation. So today we're going to cover a number of themes, including the laws and regulations enforced by State Attorneys General, the role of consumer complaints and other factors that influence investigations and priorities, what to expect in individual, multi-state, and federal co-investigations and litigation, including what to do with the civil investigative demand or subpoena and how to negotiate that, as well as also how State Attorneys General exchange information and interact not just with each other, but also with federal agencies like the CFPB, FTC, banking agencies, and others. And then ways to minimize that enforcement overreach. How can you take advantage of self-regulatory programs in your industries, or how can you individually influence and educate, advocate with State Attorneys General. But first up, let's work in our panelists and say hello. First up, we've got Senator and former Arkansas State Attorney General Mark Pryor. Welcome.
Thank you.
We've got former Chief Deputy of the Alabama State Attorney General's Office, Kevin Turner.
Hello, glad to be with you today.
We've got counsel Meredith Boylan.
Hi, good afternoon.
And new counsel Alexandra McGarris.
Good afternoon from New York.
And Allison Baker.
Good afternoon again.
So, Senator Pryor, or should we call you General Pryor today?
Call me whatever you want. Not a lot worse.
The role of state AGs is numerous, very unique, and in some states, the second in command of the state. I grew up in New Jersey, so we'll no little interesting sort of election cycle there and the way that all works with the state AG. But and in some states, the third ranking elected officer after the lieutenant governor, but often entirely independent and the chief legal officer. What are those roles, and what are some of the stuff that people don't realize about where the state attorneys general are involved?
Sure, Jonathan and Allison both. Thank you very much for having me today. And as you mentioned, I was State Attorney General in Arkansas from 1999 through the end of 2002, and loved the Office of State Attorney General. It's quite an institution, and oftentimes is not well understood by those who are not familiar with it. And I'm delighted to be joined by Kevin Turner, a partner here, who happened to also be the Chief Deputy Attorney General down in Alabama for A.G. Luther Strange. So we'll try to handle this question if you're okay with that, Jonathan. But basically what the state AGs do, their primary basic function is they are the chief legal officer for the state. And that means a lot of different things in different states. Some of this is state by state, but basically for most of them, their responsibilities include enforcement of both criminal laws, but also consumer protection and trade laws. And so what that means is when it doesn't matter if they're Democrat or Republican, enforcing consumer laws is very bipartisan. Really across the nation, if you want to talk about state consumer law enforcement or even federal enforcement at the state level, you're going to be talking about the state attorney general. And also one thing to always keep in mind with state attorneys general is that they are almost always, with a handful of exceptions, they are elected officials. And many times, again, it depends on the state, but many times they're going to be completely independent of the governor and the legislature for that matter. They may all be of the same party, but that doesn't mean that the state attorney general has to follow what the governor says. It's truly an independent office in most states.
Yes, Senator, thanks. So what we've seen over the last few years is an increasing amount, to the Senator's point, that these are elected politicians. We've seen an increasing number of attorneys general getting involved in policy matters, weighing in at the federal level on proposed regulations and rules and proposed legislation, both for and against that, both for the creation of the CFPB and against the creation of the CFPB, litigation against Dodd-Frank and trying to overturn that constitutionally by a significant number of attorneys general. And so they really are now weighing in and using their bully pulpit at the federal level. At the same time, in many instances where they're fighting the federal government, they're also working very cooperatively with federal counterparts at the CFPB, at the FTC, at DOJ on multi-state investigations. And that's a powerful combination when you put federal regulators and state attorneys general in the same room, give them a reason to investigate your company. That's not a position you want to be in.
And Kevin, these are not usually political decisions in terms of investigations. In other words, Republican or Democrat, consumer protections largely agnostic, but they are political offices.
Right.
Explain those distinctions.
Yeah, I mean, every attorney general, based on my experience, sets enforcement priorities when they're in the office. What are the major consumer issues that affect the citizens in their state? And that will determine how active they are on matters as they evaluate them on a case-by-case basis. And just as you have different, 50 state AGs, they're all, most of them elected. The way they approach those cases will also vary, and the method and the willingness to work with a company to have discussions and try to resolve a problem before a full-blown investigation or litigation. Some will do that. Others want to go into the investigation stage and handle it in a more adversarial way. You have to know the personality of the people you're working with.
And they're all not just looking out for the consumers generally, but the citizens of their state. They're very state-focused.
Right. Yep.
General Pryor?
Yeah, no, I think you're exactly right. And one of the things that we also see is that because, and this is related to what you were just talking about, because you've seen Congress become less and less productive with more and more gridlock, the state AGs have stepped in to fill that vacuum. So they become more active. In fact, as Kevin alluded to a few moments ago, with a Democratic president and a lot of Republican state AGs, it's been the states who've sued the federal government on things like the Affordable Care Act, things like some of the EPA issues, and et cetera, and they have a list. And I predict, and I think everybody here agrees, that you're going to see the Democrats now be much more activist than they were. They're going to change roles here. So now the Democratic state AGs will, I think, file lawsuits and be more activists against President Trump and, quite honestly, the Republican Congress. Again, this is going to depend a little bit on the circumstances and on the state, and it's not going to be monolithic. One last thing I want to say before we go to the next slide, and we do have a map of the states I want to show in just a moment, but Kevin Turner and I were in a meeting not long ago, and there were some general counsels there of various companies, and someone asked the question, what keeps you awake at night? And they said, the state attorneys general. That's what keeps us awake, because they're so unpredictable. They are different from state to state, and they can act very, very quickly. And that is one thing that everyone needs to understand. They can act, I mean, truly a state AG can read something in the paper this morning and walk in the office and say, I want to sue somebody today, and the lawsuit is filed that day. Very unlike a federal agency that goes through a long process. AGs can act very quickly, and of course, general counsels get very concerned about that.
In that vein, I think it would be really helpful, Senator Pryor and Kevin, if you could walk us through who comprises an Office of Attorney General's office. And I realize that every AG's office is structured a little differently, but more or less you have, I suspect, similar lines of chains of command. And one of the things that I think is really interesting, and it's something that I encounter a lot in my practice, is the utility of only speaking with line attorneys versus going up the chain, how that, in your experiences, has been received. And I suspect it's probably case-specific and office-specific. So, Senator Pryor, if we can start with you.
Sure.
Both of you can weigh in here.
Well, I do think we have a slide here that shows the Attorney General, senior staff, career staff. I want Kevin to talk about that because he wants to give some detail on that. But I will say this before we start on this slide, that oftentimes the State Attorney General's office, when it comes to consumer protection, oftentimes it'll be compared to a plaintiff's law firm because they're out there suing people. And, you know, guess what? They get a lot of money oftentimes when they do sue. They reach enormous settlements against big companies and things like that. But there is one fundamental difference that I think is very important that we shouldn't miss. If you really look and study at how state attorneys general approach litigation, it is very different than what you see in a typical plaintiff's firm. Because the plaintiff's firm, by and large, is going to go after a recovery for their client or clients or a class, whatever they're doing. State AGs will do that, and they will get some money, but more than anything, what the state attorneys general are trying to do is they're trying to change the industry's practice. And they may be trying to change just that practice just of one company, but more often than not, they're trying to change a whole industry and how an industry behaves. They're trying to change corporate behavior, if you will. And that brings with it a lot more when you're in a situation, an investigation, litigation, et cetera. That brings with a lot more than you have to deal with than just purely working out a dollar amount on a settlement. Kevin, you want to talk about this slide?
Yeah, so there are really three, as you see on the slide, three levels in an office. The Attorney General, who's generally, again, elected in a partisan role. The senior staff, which are generally the chief deputy, which is the number 2 lawyer in the office behind the AG, and really is the day-to-day manager of both the office as a whole and all the legal work in that office. And then other senior staff, other special deputy attorneys general and appointed officials, the legislative affairs shop, the communications group, all the people that are kind of the AG's core team, that are his or her guys that he brings in. And then you have the career staff, the line attorneys. These are the kind of the civil service merit system attorneys who may have been there for 20 or 30 years in some cases, that are handling the day-to-day functions of consumer protection investigations, of criminal prosecutions, of criminal appeals, all those functions that are the bread and butter of an attorney general office. You have these career staffers. And you really have to have a different approach in dealing with each of those levels. And many times it does, a consumer protection investigation may start out by an investigator in the consumer protection section reporting to a line attorney that's been there many years. Well, the front office, the attorney general and the senior staff, potentially for months might not know that investigation is going on, depending on what level it is reached. And so you may have received a subpoena from the Attorney General's office or a CID, and the Attorney General or his top lieutenants may not know that CID went out because the consumer protection staff may have the authority to do that on their own. Coming from an office that was very interested in making sure we were trying to resolve complaints up front and proactively working with companies to resolve complaints, I've found in private practice it is helpful at some point to, in certain cases, talk to senior staff and let them know that we're willing to come in and discuss the problem as soon as we hear there's an issue.
Right.
There are instances where going over the head of a line attorney or an investigator, creates offices. And there again, that's what knowing this business and knowing these AG offices, in a very complete way like our team does here, we can help clients navigate that.
That's right. And let me follow up on that, Kevin, if I may, and follow up on something Allison alluded to as well, and that is that state attorney general's offices are very different than federal agencies. Oftentimes when you deal with a federal agency, it's very important to not try to sort of use politics or go around that line attorney. You end up creating a lot more problems than you're solving there. And so, we understand that. But when you talk to a state attorney general's office, bear in mind these are elected officials. So in some way it's like dealing with, say, a governor's office or a House or Senate office. And if you do go around that line attorney, again, it depends on the case, depends on the circumstances, but many times that's okay because that's what they do. That's a big function of that office, is to try to understand the political ramifications of what's going on there. So the AG's offices are different than, say, federal agencies or state prosecutors because it's this perfect blend of law and politics. And actually, we do have a slide. We're on slide 11 now. If we could go to slide 10, that has a map of the state of the U.S. with the state AGs. I just wanted Kevin, if you could take 1 minute to walk us through that map a little bit.
Yeah, it's pretty. You can see there's a lot of red there. This is
much to my chagrin, by the way.
Just quickly, the one thing to point out is you now have the highest number of Republican attorneys general in the country in history, and so there were some additions this year. But what it's also done is you're going to have, getting back to the senator's point, the increasing activity on the other side of the aisle now. From other AGs in some of the blue states. They're going to be very active and have been traditionally very active in the consumer protection area and will continue to do that now and push back at the federal level.
Right, and Kevin, we've seen these multi-state investigations. The executive committees, which we're going to talk a little bit about later, which is the sort of the management of a multi-state. So you could have 40 states involved, but 6 take the lead with 2 really managing day-to-day and doing the scheduling and docketing and oftentimes helping to set the pace. That's usually shared co-equally, Democrat, Republican, right?
Yeah, there normally is there is a bipartisan nature in most of those executive committees. It may not always be 50-50, but there generally are some very big state, red and blue states, population-wise, that are leading the nationwide multi-state efforts.
Yeah, that really they're not going to sit on the sidelines just because they're Republicans or just because they're Democrats. It's if somebody's going to be looking at something, people eventually decide they want to be in.
Right.
That's right, and that's a good point. And again, most of these state AGs are elected officials, and many of them will, before too long, run for governor. They will run for the Senate or Congress or something. Who knows what? But so it's not what they do in their job is not a partisan. It's not a red versus blue thing in most instances.
So proactive outreach and engagement is a big part of companies' portfolios, whether it's consumer relationships, but also relationships with elected officials, as well as also just the constituencies and the stakeholders involved. In the state AG community, there's a couple places that often happens. Kevin, what are they?
Yeah, so you have the first one is the National Association of Attorneys General, which is a bipartisan, the national bipartisan group of all the state AGs that put on conferences every year, educational programs for several days, serve training functions for state AG offices, go into states and train line attorneys how to be a better prosecutor, how to conduct a better consumer protection investigation. So that's the first group. Then you have the partisan groups, RAGA, Republican AGs, and DAGA, Democratic AGs, that have several meetings a year that bring those caucuses together, both on a political side and in a policy side, of bringing panels of things of interest to their caucus and to their supporters to talk through those issues. And you also have the Conference of Western Attorneys General, CWAG, which again has panels and conferences throughout the year, majority focused on Western issues. They're expanding that now, but land use, things that were typically you would deal with in the West, that are of not necessarily interest to everybody across the country. But the major point on this slide is that companies across the country, hundreds of companies and hundreds of people come to these meetings because it's a chance to engage with the AGs and their senior staff and develop a relationship with them, have them all in one room, talk about your company, explain your business, say we'd love to come visit with you in your home state. Can we get that set up? And so that's, a major part of what I do is helping companies navigate that process before they have an investigation, before there is an issue, of being engaged with state AGs. And as we always hear, Senator, the line,
know them before you need them. That's right. That's what some people say on that. And let me say this, that from business's standpoint, sometimes with some industries, some companies, just part of doing business, you need a state attorney general strategy. You need to understand what they do, where sort of the boundaries are, et cetera, because that's an important part of you doing business and you functioning. But we also want to caution you to always keep in mind that the interactions with government officials is more often than not regulated by state ethics laws and regulations. So you need to be very careful and very clear, and you should always talk to your legal counsel before you do reach out to those offices, because you don't want to trigger an ethics problem.
I wanted to ask you both, Senator Pryor and Kevin, if you could talk a little bit about, for example, the different working groups or committees of the National Association of Attorneys General, for example, the Consumer Protection Committee. And in part, I think that the work of those subcommittees is very important because it often is what spurs multi-state investigations, as I understand it. So maybe you can explain the importance of that. And it seems like in this day and age where we have renewed interest from states, particularly in the consumer finance space, that these committees may actually play a very important role in collaborated enforcement actions.
Yeah, so certainly, Allison, on the Consumer Protection Committee, that generally would be co-chaired by an R and a D, Republican and Democrat AG, and then it would be composed of staff attorneys in AG offices across the country, whoever wants to participate. So there is a data privacy and security working group under the Consumer Protection Committee. That may have 20 states involved in it, it may have 40 states. As issues pop up on data breaches, for say, you might have a committee formed on a specific company in a specific investigation, and those states would work together. But you've seen it where basically states become every state AG office has limited resources, and so they focus on where can they provide a value. And so some states may say our really big focus is data protection. Another AG office may say we have the ability to keep a couple of people on antitrust investigations full time, and so they'll spend their time leading and serving as a resource for all the other AGs on that. And so it's a shared responsibility of work, and they're in constant contact, at least through monthly calls, discussing all the current investigations and, more importantly, the potential investigations that might be launched and what the states, how they could work together to do that.
Yeah, and importantly, when we're talking about consumer financial services, we're talking about a set of laws that are both very specific and in some cases extremely broad. Not all that different than the federal level. But Meredith, Allison, what laws are enforced by state attorneys general?
Thanks, Jonathan. What we've been seeing in our practice is that the state attorneys general are interested in enforcing their UDAP type laws in particular. And these are the laws that are very broad, they're very amorphous. They allow the states to examine conduct of the different businesses that are operating within their jurisdictions and really try to examine whether any practices that they are engaging in relating to the consumer space are possibly unfair or are deceptive, and this can be in marketing, this can be in their interactions with consumers through their call centers, this can be in connection with how they're processing their information internally. What are they doing with it? Are they, are these companies being forthright in their disclosures? And what we've also seen is that some of the states have laws that may even be more protective of consumers than the federal laws are. And so in some instances, I think maybe to distinguish themselves from the federal agency, particularly if it is a multi-state type investigation that has a CFPB component as well, they may find a regulation in their own books that is discrete, that can give them their own independent hook into a potential investigation and their own specific cause of action. And so I would encourage people to be mindful of not only these UDAP type laws, but also other laws that could give an independent attorney general their own platform to stand on when they're investigating a company. Perhaps there's a certain disclosure that has to be on a document that's mandated by state law. Those are the types of things that you want to pay attention to in addition to your general UDAP type authority.
This is Allison. I wanted to add to what Meredith was saying. UDAP is, of course, unfair, deceptive, and with the case of the CFPB, abusive acts or practices. And all states have basically UDAP statutes. But in addition to that, we have up here on the slide an interesting note about Dodd-Frank. The Consumer Financial Protection Act, which is the enabling statute for the CFPB, it's Title 10 of the Dodd-Frank Act. Section 1042 of that statute has an interesting provision in it. It enables state attorneys general to bring actions under the CFPB's UDAP authority to enforce the Consumer Financial Protection Act. And I wanted to just briefly touch on some of what I understand to be some of the legislative background behind that and kind of some of the policies that animate that particular provision of the statute, because it's really interesting when you start thinking about the ways that state attorneys general and, for example, the Consumer Financial Protection Bureau can work together and what this statute spells out. At the time that the Dodd-Frank Act was enacted, of course, it was at the tail end of the financial crisis. And one of the animating concerns of that statute was that there had been a lot of very aggressive and well-enforced consumer financial protection laws in the states. And the Dodd-Frank Act did not want to stamp on those laws. It didn't want to take away from the relatively robust enforcement actions that state attorneys general were already taking in this space. It wanted to give those offices an opportunity to use this other tool to further enhance what they were already doing. And there was a real concern that the federal law here not be used to preempt the state laws that were going on. And so it's an interesting dynamic, and it's almost contemplated in this statute that there could be a scenario where you might see a waxing and waning of federal and state authority. So you might see a more robust federal regime versus a less robust state regime and vice versa. And I note this because there's a couple of cases that have already been brought by state attorneys general and other state actors, such as the New York Department of Financial Services, that have expressly used this provision of the Dodd-Frank Act to use the Consumer Financial Protection Act to further bring their case. And it will be very interesting in years to come if the state AGs end up creating part of the UDAP and CFPA doctrine that ultimately is enforced, of course, by the CFPB as well. Senator Pryor and Kevin, I don't know if you have any thoughts on that issue, but it just, when I've read this statute many times, it's always kind of stood out in my mind as one of the more unique things in this law.
Yeah, definitely. I think it is a unique feature, and I remember being in the room at many of these NAG meetings and having Elizabeth Warren and Rich Cordray both there to talk about this interaction between how state AGs and the feds could work together through this provision. And some states have taken that to heart and have done that. And there was a working group, and there may still be, on the Dodd-Frank matters at NAG.
Yeah, and then consumer protection laws that are enforced by state AGs also include more than just the UDAP statute. The mini FTC Act for years is how they were referred to. But besides deceptive or unconscionable acts and practices against consumers, most states also have consumer protection laws regulating debt collection, credit reporting, credit servicing, lending, loan servicing, debt relief services, money transmission, and so many other consumer financial services categories. And oftentimes there's, in some cases, a duality in enforcement regimes where the state banking department or state department of financial institutions may have independent authority or perhaps co-equal or delegated authority to the state AG's office to do the enforcement prong. So for instance, like in Maryland, while it's the state AG's office that enforces a lot of the credit and debt laws, they're essentially housed at the Department of Labor Licensing and Regulation. So there's a sort of an interesting and important note there, particularly for companies that hold state licenses and are supervised and examined on a regular basis. More often than not, that's how stuff would be caught. It wouldn't be through an investigation, but the path may still lead to the state AG's office. So there's been a lot of enforcement activity, and we expect it to increase. But I think what would be significant is just to get an understanding of what that type of activity has been.
Sure. So we are seeing a lot of focus on student lending. This is an area that Elizabeth Warren is certainly interested in, and a lot of these state attorneys general are interested in as well. They are looking at a lot of, post-Great Recession activities or activities that may have occurred during the Great Recession that clued them into potential abuses that occurred during that time frame that they're trying to prevent going forward. And the state attorneys general, I think, are really trying to look out for consumers going forward in these transactions and trying to, again, change the industry, not just get these large monetary penalties that we see here, but also try to improve the industry as a whole. And you can see through these particular examples that some of this is being accomplished through state and federal collaboration.
Yeah, and that collaboration is significant. And also, it's interesting to note, it usually oftentimes is not just the primary actors in a space or the ones that might have a black mark against them as a result of consumer complaints or otherwise, but frequently folks that span the entire ecosystem. So, and oftentimes in, let's say, mortgage or in debt collection, it's been the original lender that's been looked at, as well as also a collector, perhaps a debt buyer, and so on.
And I think another thing that's interesting here, and I'd be curious to get Meredith's view on it as well, given her practice, but we note that, like, for example, the CFPB and the Department of Justice and other federal players, the AG actions in this space also pay particular attention to what I like to call vulnerable consumer segments. So folks who fall into certain consumer segments that are particularly susceptible to scrutiny and protection for good reason, such as students, such as service members. And I'm curious, Meredith, if you have some thoughts on that as well, and how that might dovetail also with federal agenda items.
Right. I absolutely believe that, protecting students, protecting service members, protecting people who are in, perhaps in an underbanked situation is a bipartisan interest. And so, I see that going forward, both the state attorneys general and from a federal regime are going to be very interested in protecting these types of classes. And again, I think that as Jonathan was saying, they're going to be protecting them across the spectrum, not only in, the loans or the mortgages that they may be getting, but in how they are being, collected after the fact. And so there are a lot of different players in all of the food chains regarding these different financial products. And so, all of them are within the scope of these types of investigations that we've seen through our practice.
And, the classic example of how folks can get on the radar is consumer complaints, but there's also a lot of other factors as well that come into play. In some cases, they're real large industry shifting issues. In some cases, they are simply just the totality of consumer complaints or the phone call or commercial that somebody sees on TV that they then automatically say, well, let me send a civil investigative demand, and we've all seen that. Alex, what are some of the triggers for a state AG investigation, and how have you seen that play out?
Sure, thank you, Jonathan. So this is a slide that I've actually repurposed from some presentations I've given relating to the CFPB. I mean, I relooked at the factors, made some adjustments, and while I think that the various factors are pretty common across the federal and state and among the state enforcement agencies, there are different emphases. And so when we talk about a state attorney general, just like any other law enforcement agency, of course, if there is a clear violation of consumer financial law, however it's identified, discovered, whether it's self-identified and reported by an organization, or if identified through complaints, etc., that will immediately could immediately trigger the initiation of a full-blown investigation. But there are other things, and one we just discussed is risks to consumers or specific markets or populations of consumers that, based on the Attorney General agenda and priorities that he or she has set forth, or that are generally understood to be populations that need to be carefully protected, those products that target those populations will always be looked at more carefully. Of course, there's always a possibility that an employee or former employee that perceived potential misconduct or violations at the company could become a whistleblower and go to the AG's office and kind of become an informant that gives the office access to information that it otherwise would not be able to get quite so easily. The most important, and we'll spend a little bit more time on this on the next slide, is consumer complaints. And we've seen, of course, other federal agencies be mindful of consumer complaints. The Federal Trade Commission has for decades run Consumer Sentinel, a database of consumer complaints from various sources, including the state AGs, the Better Business Bureau, et cetera. The CFPB, of course, the last few years has really kicked up the game with respect to not just receiving and analyzing consumer complaints, but handling them. And that's really, I think, modeling after the state AGs. And we'll talk about complaints and the role they play in the initiation of an inquiry in a moment. But another area, and Jonathan alluded to this, which is slightly different than the Federal Trade Commission, for example, is that many entities in the consumer finance space are regulated on a state level, oftentimes by a different agency. They're licensed, whether it's a lender, debt collection, various other entities that touch money on behalf of consumers. They all need to be licensed to operate in certain states. And that all typically goes hand in hand with a supervision relationship where the state regulator, the licensing body, can and examine an entity on a regular basis or on demand, and that gives the regulators access to a lot of information that's very easily handed off to then the law enforcement body, the state attorney general, which has different tools at its disposal to actually enforce the laws. And then media coverage, and I think this is one where when we talk about emphases, the state attorneys general as political animals are very mindful of media coverage of companies that operate in their state, that touch their citizens, constituents, voters, and are very sensitive to media coverage, both about the companies operating in their state where they're not doing something about it, or positive media coverage when they are able to bring an enforcement action, get a big settlement, and grab those headlines. And so all of these together can contribute in different ways to the initiation of an investigation. And before we do turn to consumer complaints, I'd like to hear, Senator Pryor, Kevin, if there are any of these factors that you think are worth additional commentary or are particularly important to an AG's office versus another type of law enforcement body.
Well, this is Mark Pryor, and on that one, I might say media coverage. This is something that makes dealing with the State Attorney General's office, again, different than, say, a private sector law firm, say a plaintiff's law firm, because the State Attorney General, anytime he wants to have a press conference, they show up. And he's going to be on the front page of the paper, lead story in the evening news, that type thing. And there are some AGs that really, thrive on that. The truth is most of them are very responsible and they don't, exploit that too much. But it is an element of the office that you just have to understand that that's a real facet of it. I guess the other thing I was going to say is in Arkansas, and I'm sure it's true in every other state, Kevin may comment, but we had a consumer protection database. And so when we would get a complaint on a company, it was in the database. And, it may, have one, we may have one on a company today and we may get 20 more. Well, we know that. And, we can go back, 4, 5, 10 years, whatever it is. So anyway, just the point is that they pretty much are doing the best they can to track what's going on in their state. And if you're someone who's had a lot of consumer complaints, and of course they're working with Better Business Bureau and other people like that, that's going to come out, and that's just something to be aware of.
Yeah, and those complaint databases, they're pooled. Consumer Sentinel, run by the FTC, pools State AG, Better Business Bureau, CFPB statistics. Obviously, CFPB's got its own portal as well. But a lot of this is shareable, and they can track trends, not just in their own state, but they can then look at what's going on elsewhere too. While oftentimes state AGs are, without question, first looking out for the citizens of their states, I've had plenty of investigations where the interests of other states have sort of overlapped, and certainly the facts have. So, what's really probably next important is not just understanding where all this comes from, but what to expect during an investigation or litigation. It usually starts with not a knock at the door, but rather the issuance of a civil subpoena or civil investigative demand, which has a whole dynamic to itself, particularly if it's a single investigation versus a multi-state, and a lot of strategy and thought needs to be given to that. Meredith, when you see civil investigative demands or subpoenas, where do you start?
Sure. So I think the first place to start is, you want to see if you can suss out from the beginning of the subpoena, what laws are they looking at? What's the area of the law that they're curious about? And then, of course, you want to look at the information that they're requesting and try to get a feel by piecing those together as to where do you think that they're going within your organization. And some of this you may already have a lot of insight into because, as Jonathan and Alex were saying, a lot of these investigations do arise from an examination process or some other route that ultimately leads to the state AG's involvement. Once you, as part of this, you're going to assess the scope. How big of an investigation is this? Is this a discrete request? Am I the target of this investigation? Are they trying to get information on somebody else? And then, determine what is the best way that you can go about responding to this. Is it to cooperate? That's probably what you're ultimately going to want to do. And then, enter into a dialogue with the attorney who issued the subpoena. Maybe there's ways that you can narrow the scope of it. Maybe there are, agreements that you can come to as far as the timing of your response. A lot of these CIDs have, a mandated response time that does have some flexibility once you actually speak with the agency, but some of them have certain turnaround times that you have to keep in mind in reaching out to the Attorney General in order to speak about that narrowing.
And Alex, we've dealt with multi-state investigations quite frequently where there's oftentimes more than one subpoena, but they're usually duplicates. And then there's oftentimes upwards of 40, 48 states, maybe even all 50, plus the District of Columbia. And that all has to be, the whole process here has to be repeated and negotiated. Talk a little bit about that.
Sure, thank you. And before I do, I was actually going to make a point about single state CIDs, and that in this initial stage when you're first kind of assessing the request before you, the civil investigative demand, and as Meredith said, kind of get a sense of what practices and laws are they really looking at, and these CIDs can be all over the map. Some are just asking very broad, open-ended questions about your entire business operations, and some really are focused. So one thing to keep in mind with respect to a state AG CID is that you want to always think, well, what are my operations, my touch points in this state, and think about it in terms of when you're trying to assess, what your risks are if you start disclosing information, how burdensome it could be. Is you want to think of it through the lens of just your contacts with consumers in the state. But with respect to multi-state, so going the other direction, dealing with a multi-state, whether it's self-initiated or kind of thrust upon you because the states have banded together in order to take advantage of shared resources and reduce redundancy, which ultimately is a good thing for an organization as well, instead of having oftentimes to deal with these on a one by one. They don't always start so neat. And so it takes a lot of work up front in order to corral the participants. And there is some room, depending again on the specific circumstances and how it was originated, but there is some ability to kind of actively shape how it's going to play out, which states are going to be participating. But ultimately, the states are going to organize themselves, get their act together, and appoint a subset of the participants to serve as an executive or steering committee, so that all communications and just can go through a subset of states, and that they would ostensibly be the primary shareholders, stakeholders that will make the big decisions and communicate and represent the entire group. It takes a lot of work up front to set it up so that it's streamlined, efficient. But once that structure, the infrastructure for communications is created, a plan for responding either to document requests, information requests, or negotiating and actually having substantive conversations. Typically, in a multi-state, different participants will have different roles. So you want to make sure you have these conversations and clear kind of lines of responsibility and understandings up front. And then as it unfolds, and these typically unfold very slowly because, as you can imagine, it's a human nature when you have multiple stakeholders. Then one, you've got a lot of on the back, on their end. They have to convene a meeting every time a decision's made and have to get their supervisors in turn to agree on something. So it doesn't move very slowly, and you kind of want to constantly have regular check-ins with that steering or executive committee to reconsider whether the way it's organized continues to make sense, to make it efficient.
And Alex, that's a real people process, right? It's person to person, it's relationship based as much as anything else.
Well, I mean, I think as Kevin and Sen Mark Pryor could speak to even better than me, I think dealing with the AG's office, whether it's a single office or a multi-state, is very people-centric, especially when you compare it to a lot of the federal counterparts.
Yeah, I agree 100%, Alex. I think, again, as we said earlier, these offices, there are 51 of these in the U.S. that you're dealing with, and they're each different in the internal workings and the staff in those offices. And so getting to know those people and knowing those personalities is an important part of this whole process of effectively navigating an investigation.
Yeah, and whether it's a multi-state or a single-state investigation, there's a lot of steps involved that are similar, particularly after that multi-state apparatus is set up and negotiated, which can take months. But that being said, Meredith, what are some of the practical steps that are involved in assembling not just the facts, but also understanding the law and then responding to the request?
Sure. So, it's going to be a pretty dynamic process, and I think part of making it as smooth as possible, and it's that people relationship on both sides, both with the client and with the state attorney general's office itself. You want to establish credibility and trust with your counterpart at the attorney general's office, because the reality is most of these investigations are very complex, and they're not going to proceed on a necessarily a very smooth and expedited timeline. But at the same time, you have to be working with your client to try to allow them to realize the importance of this investigation and to make it a priority, and that these are real and that there are potentially very substantial consequences to that. And so you have to work with your client to assemble a team within their organization that can help facilitate the responses you have to provide to the Attorney General. And some of the bullet points on this we've already hit on, but again, if you're able to get a scope, initially of what's the problem that your Attorney General seems to be concerned about, immediately try to get a handle on the volume of information, whether that's a data-driven inquiry, maybe it's a report, and they may be seeking reports on thousands, hundreds of thousands of accounts or client files, and so that's one type of very onerous response to put together. But then of course there's your documents, and so getting a handle on who are your key players, who are your custodians, where are these documents, how voluminous are they, can help you engage in a productive dialogue with the Attorney General's office that can make for a credible and collegial relationship that can ultimately, I think, inure to the client's benefit, because you're not trying to obstruct the investigation. You really are trying to bring both parties together in a way that resolves it.
One question I have, Meredith, this is Allison, is once you've kind of gotten a sense of what this investigation is about and what laws may be relevant here, how do you go about figuring out what types of facts could paint the wrong kind of picture? Because it strikes me that when you're producing documents, you like to know before you produce them what the narrative is going to look like from the state AG's perspective. And curious about your views on this, Meredith and Alex.
Sure. So yes, you want to, I think this also goes to, you want to engage with your client and understand what is the business line that the AG is interested in. Your client has to be frank with you, and what are the soft spots within that business, in that industry. And again, what Alex was saying, if it's a one state, what are the particular interactions that your client has had within that state? And as an attorney, I think you want to get a sample of, you want to maybe speak to some of the employees, get a boots on the ground type analysis of what was really going on in the day-to-day workings of this business before you start rolling out information, because you want to have some sort of context to at least understand the potential pitfalls that your client could be exposed to by turning the information over.
And for those expecting CLE today, please stand by for the CLE code. We've got about 4 minutes to go. Alex, boots on the ground, important?
Yeah, so I would say Meredith and I have handled so many of these, and each has a little bit of a different flavor, but in terms of things that are common to all successful, and that's also a relative term, successful kind of outcome to an investigation, you need to get the business people involved right away. Oftentimes, these inquiries, these CIDs get cabined off in the legal department of an organization. Outside counsel gets involved as well and serves as the interface between the client and the AG's office. And the materials that are requested and have to go from the company to the AG's office, are kind of collected and turned over in a vacuum, and that's a recipe for disaster. The sooner the business people, the subject matter experts on an organization's operations that are being looked at for potential violations of law, the sooner that they can educate not just the in-house legal people, but the outside counsel that's going to be framing the issue up for the AG's office, the better. And then the second common thing is, credibility. For whoever's participating in this process, having credibility and transparency with your counterpart at the AG's office is absolutely paramount.
Yeah, and a combination of the two is really where the magic happens. And then again, the relationship aspect of it all too, going back to that political nature of a state AG's office and the Attorney General, him or herself. And of course, listening to what the concerns are and then incorporating that into the compliance program is also important. Being in compliance, doesn't just mean responding to the requests, but also demonstrating that the law and the regulations are followed, and importantly, that you have the capacity to understand and reflect upon whatever it is the issues may be. Because whether or not a company believes there's issues, if the state attorney general has subpoenaed the company, they at least initially think there is some basis for a concern there. And enhancing the compliance program to meet those expectations is also important. So managing and enhancing compliance, as we all know in our practices and going in and working on CMS programs day in and day out, is not something that happens in a vacuum. It also is not something that really ever ends, but rather is never ending. And an effective CMS can process the consumer complaints, process the substance of what a request is from a state AG's office or a multi-state, and then react accordingly and appropriately. And whether that's adjustments to training or monitoring and corrective action, or to the policies and procedures of the organization, or anything else related to the compliance management system, all of that becomes critical. Stand by for the CLE code. We'll be providing that in just a moment. Some final observations? Allison?
Yeah, I think that this is an area that we're going to see increasing coordination between state attorneys general, other types of state regulatory agencies in the financial services space, and federal actors. In addition, I note that we had a number of questions today. I'm not sure we got a chance to answer everybody's question, but I would like to encourage those on the phone to feel free to reach out to any of us with any further questions you have about anything we said today or anything related to what we said today. And again, thank you for joining us.
Thanks very much. This is Meredith Boylan. Again, we hope that this has been a productive afternoon for you. We have a lot of experience here. We were happy to share some of our knowledge with these investigations, and we look forward to hearing from you.
And Kevin, we've now got this unique dynamic, as you mentioned earlier on the session. You got the most Republican attorney generals than has ever existed in the history of the United States. But we're also coming off of 5-8 years of really intense scrutiny of consumer financial services. Do you expect that to continue?
Absolutely. I think as we talked about earlier, you're going to see an increased, intensity among some state AGs to really challenge the administration and their efforts to potentially roll back some of the things that have been done in the last 8 years. And one member of our team who isn't here today, but Eric Jones, was Policy Bureau Chief for current Illinois Attorney General Lisa Madigan. And so,
she'll be in the lead on a lot.
Right, she'll be on the lead on a lot of this. And he was dealing day-to-day with all of these consumer protection issues and working across the country with offices and those staffers. And so between the senator, myself, and Eric, we've got a great team that have been came out of these offices recently and know these folks that are currently there, and just happy to be able to help you any way we can.
And Alex, the boots on the ground are really important, because now more than ever, whether or not somebody's doing something right or wrong will be balanced by the fact finders that are looking at it, right?
Well, we certainly hope so. But regardless, you always want to be able to tell the best story you can, even if there has been, an error, a mistake, or, a violation. To the extent you can mitigate it and and present a story that the company cares about compliance, has a system in place to ensure it. It's always going to have a better outcome, regardless of one-off incidents. So absolutely.
Senator, former Attorney General Pryor, last word.
Well, I want to thank everyone for being here, and if you've sat through this presentation, this slide we're showing right now may be the most important one, and that is that we're available to talk about this. We want to talk to you about it. Those are our cell phone numbers and email addresses, and please reach out. You can tell we have a great team here. We do this a lot and do a lot of it. So thank you for participating today. Thank you for your questions, and like I said, we'll be glad to visit with you further if you ever need that.
And folks, thank you for joining us this afternoon. Again, this is Jonathan here, and just a small commercial. Consumer Financial Services 2017 Outlook, January 24th, 2017, 2 to 3:30. Find out post-inauguration what's on tap for consumer financial services.